All attendees are in listen-only mode.
Hello and welcome to today's webinar entitled Year-End Roundup and Future Forecast. Thank you for joining our webinar today. It is scheduled to run approximately 50 minutes and we will have some time at the end for questions. I'm joined by Stacy Barrow of Proskauer Rose, who will be leading us through this topic today. Stacy is an associate in the Labor and Employment Law Department and a member of the Employee Benefits, Executive Compensation, and ERISA Litigation Practice Center, as well as a member of Proskauer's Healthcare Reform Task Force. Today's program is being recorded, and we will post a copy of the recording as well as the slides to the Client Resource Center shortly after today's session. Again, if you do have any questions, we ask that you enter them in the questions dialog box, and we'll present those to Stacy at the end of the session. At this time, I'd like to turn it over to Stacy to get us started for today.
Thanks, Chris. Good afternoon, everyone. It's Stacy Barrow from Proskauer Rose in Boston. We're proud to partner with the Presenter Group and offer today's webinar to their friends and clients. As Chris mentioned, today's topic is the 2014 year in review for the ACA. We're going to talk about what we saw this year for the ACA, about the marketplace rollout, some commentary on the elections. We'll talk about some interesting cases that will be coming in front of the Supreme Court next year, and then we'll give a brief ACA update and talk about what to expect in 2015, and we'll spend our few minutes at the end talking about the new reporting rules, and then a couple of approaches to avoid that we have received some guidance on in the last couple of months. So as always, we'll try to take questions at the end. Please feel free to type them into the chat box, and we'll get them answered as best we can. So in terms of a year in review, I thought it would make sense to start out with the marketplace. And I think, looking back over 2014, even the more objective observers would probably have to say that 2014 was at best a mixed bag for the ACA. If you recall, the 2014 began with these reports in the news of failures regarding the marketplace. There were news reports of the websites crashing, people being unable to enroll, having incomprehensible enrollment screens, and those were just on the federal websites. The state websites really fared a little better. Covered Oregon spent about $250 million on their version of the exchange, on their state exchange, and they had somewhat of a disastrous rollout. The website simply wasn't enrolling people. They ended up scrapping that in favor of the federal system. Even here in Massachusetts, our own version of the exchange, the connector, had a little bit of a difficulty adapting to the ACA model. Our connector had functioned for years under the Massachusetts healthcare reform, but when it came time to work under the ACA model, the system did not work as well, and we had situations where people were applying for subsidies online and they were getting letters in the mail as to whether or not they qualified. So a couple of hiccups there. But on the other hand, it does appear that at least several million people were able to sign up for coverage in 2014. And it seems that about 80% of those enrollees in the marketplace plans received some form of subsidy to enroll in coverage. I think it's probably fair to say that many of these people that were enrolling probably were folks that might have had coverage but lost it due to the ACA, but certainly a fair number of them did not have any insurance before the ACA. So right now, annual open enrollment for the marketplace is in effect. It runs from November 15th through February 15th of 2015, and while there have been some reports of sign-up and technology failures, there have not been the widespread reports of failures that we saw with the inaugural enrollment last year. We think the real problem for the marketplace in 2015 and likely 2016 as well are the premium increases. We've heard or it's been reported that the increases are in the 8 to 25% range for individual plans. And so even people that have subsidies and allow them to have affordable coverage last year may find that even with the subsidies and assistance, that the plan they had last year is now unaffordable. So it'll be interesting to see how the year progresses there. As we all know, 2014 was the year that the pay-or-play mandate was supposed to be effective for employers with 50 or more full-time employees, including their full-time equivalents. The administration delayed implementation to 2015, and then they further delayed it in February of this year when they provided transition relief for employers with 50 to 99 FTEs and for larger employers with non-calendar year plans. The IRS really needed some time to work on their reporting forms and processes, which we'll talk about later, which will basically be the backbone of the implementation. So this coming year, 2015, is really going to be the time that for employers with 100 or more FTEs, all of your look-back methods and record keeping will really be put to the test, and you'll start offering coverage to employees that average 30 hours or more. We'll talk about that in a little bit. Oops, oh no, let's skip to the end. Okay. Just a word on the election. Back in November, as you know, the Republican Party took control of the Senate and added to their votes in the House. Real story here is that the states, they basically won control of about 29 state legislatures. Number of states that previously or traditionally were thought of as blue states have seen some Republican governors, like Massachusetts, Illinois, Maryland. You know, these are traditionally blue states. They now have Republican governors. And from the ACA standpoint, you know, obviously the regulations come down from the federal government, but the governors and the state legislatures have a lot of input into the implementation of the ACA Act, or the ACA. We might see in those states that are either controlled by Republicans or have Republican governors that they may take a little closer look at some of the mandates coming into effect, and they could delay or otherwise affect those mandates. You know, one of the things that we've heard a little bit mumblings about is whether there'll be any delay in the expansion of the small group market to go from up to 50 employees to up to 100 employees in 2016. That's scheduled for 2016. And as we saw this year and last year, there are delays in the implementation of the small group market mandates that occur at the state level. And so it's certainly possible that some states could maybe delay that expansion further. This will be something that we'll be looking at in 2015, and we'll certainly keep folks posted as to whether there are any changes to those proposed rules. In 2015, I think, is going to be a very interesting year for the ACA from a judicial standpoint. This year, the Obama administration fell down 2-1 in Supreme Court decisions. In 2012, they split with the court. On one hand, the Supreme Court upheld the individual mandate, but on the other hand, the court struck down Medicaid expansion. Then in this year, in 2014, the Supreme Court also found against the Obama administration that it violated the Religious Freedom Restoration Act in the Hobby Lobby case. And here the Supreme Court said essentially that the government could have used less restrictive means when dealing with religiously based for-profit employers who have religious objections to emergency contraceptives. So one case or challenge I think we'll see in 2015 is whether the opt-out accommodation is the least restrictive alternative. And the way it works is that if you are a religiously affiliated employer and you want to opt out of offering the coverage for emergency contraceptives, then basically you send a notice to your insurance company or your TPA if you're self-insured, and you notify them that you're opting out, and then the insurance company or the TPA will make those emergency contraceptives available because the participants still have a right under federal law to receive that care. And so the challenge here brought by certain employers, again, those with the religious objections to contraceptive coverage, is that the opt-out itself is not the least restrictive means, because these folks, and it's a good argument, say, well, if we can opt out, and then we have to tell the carrier that we're opting out, and then they can make the coverage available, we're still ultimately providing it. And so they would rather inform the government and not disclose the name of the insurance company and not disclose the name of the carrier, and so they can opt out without violating the rule, and then they can be sure that the participants won't have access to those contraceptives, at least under the terms of their plan. And I don't know the likelihood of whether that will succeed. I think it falls on RFRA grounds. I think it fails. There's a case that it's kind of a similar set of facts where there was an individual who was a conscientious objector and did not want to be drafted, did not want to fight in the war. I think this happened to be the Vietnam War that this case was about. And the conscientious objector, when he went to meet with the recruiter, the military recruiter, explained that he was going to opt out and that he had a religious objection. And the recruiter said, well, okay, that's fine, but someone else is going to go in your place, and you're going to be responsible for that person, basically. And so the individual sued, and he said, it's not good enough that I can opt out of being in the military, but there needs to be a vacuum there. They can't go fill that space with someone else. I want to make sure that my opting out doesn't result in someone else having to serve. And the court in that case said, it only goes so far. You can opt out, but you can't tell the government how to run the Army, and you can't create an empty space where they needed someone. And so I think the analogy holds with this case where the opt-out of notifying the carrier so that they can provide the benefit, I do think is the least restrictive alternative. But again, the courts will decide that one, and that may be something we'll see in 2015. So interesting cases there. Perhaps the most interesting case coming up in 2015 is the King versus Burwell case. And this could really be a death knell for the ACA if the court finds in favor of the petitioners. And so the issue here is whether the Affordable Care Act provides for subsidies in states with federal exchanges, or are they limited only to being used in states with state exchanges? The argument here is that on its face, if you look at how the ACA is worded, the statute itself, you can make an argument that the subsidies are only available for coverage purchased in state exchanges. And the majority of states, about 37 of them, have federal exchanges. And so if the proponents are right, then any state with a federal exchange would basically not have an employer mandate. Employers wouldn't be penalized because their employees could not get subsidies, and that's what trigger the penalties. So while it would be devastating for your average Americans that needed the subsidies, you have millions of people losing coverage, it would be good from an employer standpoint because they just simply wouldn't have the pay-or-play mandate in those states with federal exchanges. So this case really can go either way. We have an extremely conservative Supreme Court, and so you never know what they're going to do here. On one hand, I think the administration, I'm sure they're a little nervous, and they probably don't want a chance going down 3-1 here. If this case were to go against the administration, I think it would really be a knockout blow to the Affordable Care Act and could be very disruptive to the insurance markets. Although, I do think it's pretty clear that the law was drafted to provide for subsidies in state and federal exchanges. Kind of takes a tortured argument to come to the opposite conclusion. But at any rate, maybe the smart money here would be for both sides to work together, and I am serious about that. But I know it's probably it's probably very unlikely. We have not really seen a whole lot of bipartisan efforts here in the last couple of years. If anything, though, the two parties could come together and maybe change some of the aspects of the ACA that both sides agree maybe don't work, like the medical device tax, 3.8% or 3.2%, whatever it is, medical device tax. There is some bipartisan support on both sides to get rid of that tax, and so maybe they could compromise here, amend the law to make it clear that subsidies are available in state exchanges, and at the same time repealing the medical device tax. A little more of maybe a pipe dream or wishful thinking would be that the administration also agrees to change the 30-hour threshold to 40 hours. That one I just don't think it's that likely to be agreed to at this stage of the game. But again, this is a very interesting case to keep your eye on in 2015. We should have oral arguments in March and then a decision sometime in June. Okay, just a quick update on same-sex marriage. As you know, in 2013, the Supreme Court struck down Section 3 of DOMA, which defined marriages between one man and one woman for purposes of federal law. And the court left intact Section 2 of DOMA, which allow for the state mini-DOMA laws. And so as a result, as of last week, we have same-sex marriage legal in about 35 states and in a couple of districts, and it creates somewhat of a patchwork here, where you can see there's still a portion of the country that the residents really don't have that equal protection that residents of the rest of the nation have. Again, another testament to the Supreme Court being somewhat conservative. There will probably be more lawsuits challenging the state mini-DOMA laws in 2015, and so we'll keep you updated on that front. Just as a reminder, your 401k plans have to be amended by the end of this year. They were probably amended last year, so you're probably fine there. It's possible that if you are an employer in a state that doesn't recognize same-sex marriage, but you offer same-sex benefits, there could be a bifurcation of the tax treatment. You should talk to benefits counsel directly if you have questions on that end. But in general, that's the story on same-sex marriage. Something else that we noticed in 2014 and we expect to hopefully be resolved in 2015 is the issue of the EEOC in their stance on wellness programs. So as we know from the Affordable Care Act and by other actions taken by the Obama administration, that they consider wellness to be an important component of healthcare reform and of consumer-driven healthcare in general. However, it seems that they neglected to tell the EEOC. As you know, the EEOC is the agency that has enforcement authority over the Americans with Disabilities Act. And as we've talked about in the past, these two agencies, the EEOC and the Department of Labor, don't see eye to eye on the use of mandatory HRAs. On one hand, the Department of Labor allows employers to condition eligibility and the amount of premium contributions on an employee's completion of an HRA and a biometric screening, as long as you're not using the results to delay or deny eligibility or to determine individual premiums. So, on one hand, the DOL says that mandatory HRAs are okay, but on the other hand, the EEOC says that involuntary HRAs are a per se violation of the ADA. So there's been at least 3 lawsuits in the last 4 or 5 months challenging various employers' wellness programs. They all seem to be coming out of one office of the EEOC in the upper Midwest area. There could be challenges in other parts of the country as well. We were hoping that this year, in 2014, the EEOC would have engaged in some formal rulemaking and issued regulations kind of harmonizing their position with the Department of Labor. They ended up going the opposite route and going the judicial route. And so rather than issuing rules, they've just decided to sue employers that they feel are violating the ADA. So it'll be very interesting to see those decisions, whether they actually, how far they proceed, whether they're settled, whether the EEOC withdraws them and just starts making rules. We're sure to see some more movement on this in 2015. So again, as a reminder, the pay-or-play mandate generally effective next year. If you have between 50 to 99 full-time employees, including your full-time equivalents, on average in 2014, then you can start complying in 2016 with the employer mandate. As long as you meet these criteria below, you cannot have reduced your workforce and not had a material reduction or elimination of coverage in place, and you must certify your compliance with these rules as part of your Section 6056 reporting. One of the things that I think is important to mention is that even if you're exempt from the mandate in 2015 because you have less than 100 full-time equivalents, you still have the code Section 6056 reporting if you have more than 50 FTEs. So, again, even those that are exempt from the mandate this year, or in 2015, will still have to complete the reporting. If you're a large employer and you have a non-calendar plan year, or non-calendar year plan, then you have until the start of your 2015 plan year to comply with the employer mandate, as long as you meet the requirements on this slide. You have to have had a plan in place, non-calendar year plan in place on December 27th of 2012, and you cannot have changed that plan year to begin at a later date after December of 2012. You also must commit to offering affordable minimum value coverage as of the first day of the 2015 plan year. If you meet those 2 gating requirements, then you can delay your compliance until the start of the 2015 plan year if you meet any one of these 4 tests here. One of them looks at all employees, one of them looks only at full-time employees using a 30-hour average, and they basically just test to see if you had a sufficient number of employees enrolled or if you offered coverage to a sufficient number of employees. These tests are a little bit granular. I would recommend that if you're on the cusp of passing them, that you talk directly with benefit counsel. We can run them through with you. Or the Crescential member that invited you today also should be able to sit down with you and make sure that you're performing these correctly. These are just a summary of the rules on the slide. So as a reminder that there are 2 types of penalties under the employer mandate. There's the A penalty and the B penalty. The A penalty is really for those employers who have failed to offer minimum essential coverage to at least 95% of their full-time employees and children, and that number is 70% for 2015. So this is the big penalty. It applies, again, if you fail to offer any coverage to at least 95% of your full-time employees, and if at least one of them or one or more of them obtain subsidized coverage on the exchange, the penalty is $2,000 for each full-time employee minus the first 30 or minus the first 80 in 2015. Now, it's also important to note that the vast majority of employers that are going to be subject to the mandate in 2015 are those with 100 or more full-time equivalents. Everyone else is going to have an extension until 2016 for the most part. And the point here is that the 80 employee reduction only applies to groups with 100 or more FTEs. If you're in that range of 50 to 99 FTEs on average in 2014, and you don't meet the transition relief, and so you have to start complying in 2015, your reduction is going to be limited to the first 30 employees, not the first 80. The first 80 are only if you had 100 or more FTEs on average in 2014. The B penalty, the unaffordability penalty, this one applies if you fail to offer affordable minimum value coverage to your full-time employees and their children, and at least one full-timer gets subsidized coverage on the exchange. In this situation, the penalty is $3,000 multiplied by each full-time employee who gets subsidized coverage. And so in a way, it's less than the $2,000 penalty because this one only applies based on each full-time employee who actually goes out and gets the subsidy, whereas the $2,000 penalty is on every full-time employee in the company minus the first 80 or minus the first 30, as the case may be. Just a couple of reminders regarding the mandate. Each year, the IRS increases the affordability threshold as it relates to household income. In 2015, coverage will be affordable for an employee if the cost does not exceed 9.56% of his household income. Now, the safe harbors that we're used to talking about, the W-2 safe harbor, the rate of pay, federal poverty level safe harbor, those are all hard-coded at 9.5%. And so if you are using the safe harbors, you want to make sure that you're keying them to 9.5% and not 9.56%. Right before Thanksgiving, the IRS released some final regulations on the individual mandate and some of the exemptions that are available to individuals based on the cost of coverage. And so there's some guidance in here for employers as well, basically informing them as to how to treat HRA contributions and wellness programs for affordability purposes. There's also rules on cafeteria plans we'll talk about on the next slide. HRAs, we have very few clients that structure them this way, but if you want to structure your HRA to allow employees to use those HRA funds to pay premiums under their own employer's group health plan, then you can do that, and the HRA contribution will count as an employer contribution toward affordability. Other guidance for employers, and this is a good piece of guidance here, is that employers can treat all employees as non-smokers for affordability purposes, meaning that if you set a separate contribution rate for tobacco users, say you charge tobacco users $150 per month, non-tobacco users $100 per month, then you can treat $100 as the required employee contribution for affordability purposes, even if some of those employees pay the $150. Now, this only works if you're smoking or your tobacco surcharge is separate from other surcharges under your wellness program or other rewards. So for example, if in order to get the reduced premium, you have to be a non-smoker, and you have to have your BMI at a certain level, and you have to have your biometric screening, and you have to run a marathon, whatever you have to do, then you don't get to use this rule, and all employees are treated as not participating in the wellness program and having to pay the higher rate. You can only use this rule for the tobacco cessation component if it is separate from the remainder of your wellness program. This rule kind of raised more questions than it answered, but it basically informs employees that they don't need to treat employer contributions through a cafeteria plan as employer contributions if they can be taken in cash. And so there's a strong negative inference here to say that if the employer provides an opt-out benefit or, say, cashable flex credits that employees can take in cash, then the opt-out payment may be considered to be a required employee contribution. And so as an example, if you in the extreme, if you offer employees a choice of either free coverage or an extra $5,000 payment per year, then it seems pretty clear that the required employee contribution for the insurance is $5,000. It's the amount that they have to give up to get the coverage. It's not really free. The IRS is aware that their regulations here did not fully resolve the issue as it relates to opt-outs. We're hopeful that there'll be some more clarification after the start of the year. In the meantime, if you're out there and you have very substantial opt-out credits, or you have very sophisticated flexible benefit programs where you offer things like cashable flex credits, you should have your flex plan reviewed by counsel who drafted it, and they can give you advice where there may be an affordability issue. Okay. A couple of other quick updates. As you probably know, this year the Department of Labor released 2 new COBRA notices, the new initial notice and a new election notice that talk about the marketplaces and the availability of the marketplaces. And there's also a rule here that folks should be aware of. Basically, the way it works is that when employees terminate employment, they basically have a choice. They can either enroll in the exchange coverage at that time, or they can elect COBRA. But if they elect COBRA, say because maybe their employer is going to subsidize it for a few months following termination, once the employer subsidy ends, the employee or the former employee can't simply drop COBRA and treat it as a special enrollment event for the exchange. The employee will actually have to either exhaust COBRA or wait until exchange open enrollment. So just be cognizant of these rules and understand that subsidizing employees' COBRA coverage could, in the long run, prohibit them from getting a subsidy for part of the year. A couple of new cafeteria plan election changes are now permitted in light of the exchanges. And basically here, you can permit employees and their family members to drop your coverage mid-year in favor of the exchanges if they're enrolling in an exchange either during open enrollment or a special enrollment period. This is to put the non-calendar year plans on an even plane with calendar year plans, which line up nicely with the exchange open enrollment period. There's also another chance for an employee to revoke his election if the employer permits this type of change under its cafeteria plan. And the change here is that when an employee moves from part-time to full-time, sorry, other way around, when an employee moves from full-time to part-time status and that change is expected to be permanent, then the employee, even if he is locked into a stability period, can drop the employer's coverage as long as he commits to enrolling in another plan no later than the first day of the second full month following the revocation. And so that could be an exchange plan, it could be Medicaid, it could be another employer's plan, like a spouse's plan, and they just basically have to commit to enrolling in that plan. You don't have to play detective and make sure they actually enrolled in the other coverage. You just have to make sure that there's no, they're dropping it in good faith with the intent to enroll in other coverage. Okay. So what to expect next year? I think the first thing that we're expecting is guidance on minimum value, and in particular those plans that do not provide hospitalization coverage or that do not cover physician services, but still purport to provide minimum value. As we know, the IRS takes a fairly dim view of those plans, and very early in 2015, we expect the IRS to release guidance describing what type of hospitalization coverage and physician services needs to be provided for a plan to offer minimum value. And unless you qualify for transition relief, then these regulations are going to be effective upon issuance. And so if you have one of those MVP type of plans, you can be required then to amend the plan immediately to provide more substantial hospitalization coverage or be at risk of potential penalties. There's very limited safe harbors. If you started enrolling employees or you had a signed contract in place prior to, I think it's November 4th of 2014, then you can be grandfathered for 2015, but it's a very limited bit of transition relief. So we do encourage employers that have rolled these plans out to talk directly with Benefits Counsel, and we can advise you as to whether you qualify for this transition relief. We expect some more guidance on employer HSA contributions and how to treat them when they're not all made through a cafeteria plan. We also expect additional guidance on cafeteria plan rules. You may or may not know the cafeteria plan rules that we've all been relying on have been in proposed form since 2007. We never received final regulations on cafeteria plan rules other than just 2 sets of regulations on changes in status in FMLA, like the non-discrimination rules and the election rules and the FSA rules are all in proposed form. Okay. So moving on now to the reporting requirements. These are effective in 2015 for every employer that had 50 or more full-time equivalents on average in 2014. It'll be effective in 2015. The first reporting will be due in January or February of 2016, reflecting the 2015 calendar year. So these are fairly complex reporting requirements. Again, it applies to employers in that 50 to 99 group as well. The general crux is that Section 6055 is reporting by insurance companies and by self-insured plans. So if you're fully insured, you don't really have to worry about Section 6055. Section 6056 applies to large employers, and this requires employers to report on their full-time employees regardless of whether they offer a plan, regardless of whether the plan is affordable, whether the employees take the coverage or not. All employers that have more than 50 FTEs are going to have to identify their full-timers and report on them under Section 6056, even if they don't enroll in the plan or on offer coverage. Again, the 6055 reporting is by the insurance companies or by self-insured plans. There are draft forms available here but the important takeaway from an employer standpoint is that most employers are going to use the 1094-C form and the 1095-C form, not the -B forms. Only employers that are self-insured and that have less than 50 employees are going to use these forms, and I don't think there are too many employers who are self-insured for major medical that have fewer than 50 FTEs. So this is the one that's going to apply to most employers out there. Again, if you're an ALE, applicable large employer, then you're now going to be responsible for this new reporting. There are draft forms released. You can follow these links to get them. Form 1094, I think I have show. Okay, I'll show it to you on the next slide. 1094 is essentially like the cover sheet of a fax, where the content of the fax is going to be Form 1095-C. So what happens is the employer prepares all of these 1095-C forms, one for each full-time employee. One copy goes to the employee, one copy goes to the IRS. To summarize all of the 1095-Cs that you're sending to the IRS, you include a Form 1094-C, which is essentially, like I said, like a cover sheet. Important to note, if you're fully insured, you only have to complete the top half of the form. If you're self-insured, then you complete both sections. Here's what it looks like. This is the 1094-C. This is the cover form for the 1095-C. And here you're just providing all of your pertinent information as an employer. You'll disclose the number of 1095-C forms that you are providing, whether you're part of a larger tax-controlled group, whether you are applying for any safe harbors or if you have any transitional relief available. Then on the back, on the next page, you'll report on a monthly basis whether you've offered minimum essential coverage, how many full-time employees you have, how many employees you had total, and then other pertinent information. This is the 1095-C form. This is the one that goes to every full-time employee in the company, and if you're self-insured, it goes to every covered employee in the company, as well as to every full-time employee. So you see here, Part 1 is employee and employer information. Part 2 talks about the offer of coverage, whether you've made an offer of coverage, what the premium was, and whether any safe harbors will apply. If you're fully insured, you stop there after row 16. If you're self-insured, then you do complete Part 3, and you list any covered employees and their spouses and dependents, along with their Social Security numbers. Those requirements are quite granular, and there are detailed instructions, and they're going to be very tricky for the first couple of years. Probably the most important thing to know, though, is that as long as you make a good faith effort to comply, then as long as you meet the timely reporting requirements, you're filing timely, then you will not be dinged for any accuracy-related penalties. So do your best in this first year to accumulate the information and to complete the reporting at the end of the year, but just know that as long as you've made a good faith showing, that you should not be liable for any accuracy-related penalties. So the last topic I wanted to raise today are a couple of approaches to avoid. We'll review some recent IRS guidance on that issue. So as you've heard us talk about now for several months, again, and just to drive it home one more time, the IRS has come out with its third piece of guidance, basically prohibiting employers from paying for employees' individual market policies, either on a pre-tax or an after-tax basis. Either way, it's going to be prohibited. You're free to provide employees additional unrestricted compensation that they can use to buy insurance or buy anything else. But if you're making reimbursements that are only provided if the employee substantiates that he obtained individual market coverage, then that would be subject to challenge by the IRS and the DOL as a group health plan. So if you're still reimbursing individual market premiums, you should talk to your consultant if essential, and they can sit down with you and explain some alternatives. I've linked to the guidance here. There's an IRS notice, there's a FAQ, and there's also a little IRS note on their own website. The penalties are fairly substantial. They're up to $100 per affected employee per day. So could be as high as $36,500 per employee per year if you are reimbursing individual premiums. I'll just skip over this one. I don't want to get into the weeds too much as to why it doesn't work. You can read the slide for the gory details. The other approach to avoid is what we're hearing referred to as alternative care plans or affordable care plans. The idea here, we've talked about this in the past at some of our seminars that we've had with Essential, and that is the idea where a vendor approaches an employer and offers them a no-risk way to remove high-cost claimants from the plan and get them over to the exchange. And so, you know, the way it's pitched is that it's a win-win for the employer and the employee. The employee gets a cash bonus, the employer gets rid of the bad experience, and everyone wins. The problem is that this violates just about every law that impacts health insurance plans, and in DOL FAQ number 22, Q&A 2, the IRS and the Department of Labor describe, you know, some of these issues, and the fact that if you are paying employees to opt out and they have a health factor, then it's at the very least a HIPAA non-discrimination violation and generally also a tax code violation. So if you are contemplating one of these types of arrangements, proceed with caution, talk to your benefit consultant, and they can get in touch with us if necessary. And our last slide here, just as a reminder, you're welcome to join our Practice Center blog with that link up there, where you can get all the latest information on healthcare reform and other ERISA issues. And we also have the 5th edition of our healthcare reform book, recently released. This is up to date as of about September. Very comprehensive book. It's 300 plus pages. You get a 20% discount if you click that link. Makes a great stocking stuffer if you're mad at your family members. Get them this book. But at any rate, it is a great book and a great resource on healthcare reform. That's the end of my prepared slides. Happy to open it up to questions now.
All right. Thank you very much, Stacy. And we do have a few questions before we get into those. Just a reminder to everyone, if you do have any questions as we go along here, feel free to enter them in the questions dialog box. So the first one here, Stacy, is the pay or play penalty tracked monthly? As an example, if an employer extends coverage to all employees working 30 hours a month or more, and it is affordable based on the annual box W-2 earnings, but not affordable for a couple of months each year due to a reduction in hours, would the employer be penalized for the months that is not affordable?
Yes, the penalties are determined on a monthly basis, and so it's possible you could have an affordability issue for, say, a couple of months, but not for the rest of the year. One of the safe harbors is very useful in situations where you expect employees might have reductions in hours during the year. The rate of pay safe harbor lets you use 130 hours for affordability purposes per month, regardless of how many hours the employee works. So I would encourage the questioner to maybe think about that safe harbor and explore whether that might be a good option for their company.
All right, the next question here. What about groups of less than 10 who are partially insured? Do they report as well?
Well, if you have fewer than 10 employees, you should not be subject to Code Section 6056. If you are self-insured for major medical and you have 10 employees, then you would have an obligation under Section 6055. I'm not sure what partially insured refers to. I would expect that for most companies that maybe have a level premium plan or a minimum premium plan, if they're small, that the carrier would still perform the Section 6055 reporting. But you should make sure if you're at least partially self-insured and you're under 50 employees, talk to the carrier and see if they're going to take care of the Section 6055 reporting.
How are employers using private exchanges to pay for employees' private or individual health plans if guidance has come out against employers covering these plans?
Every private exchange I've ever seen has been on a group platform. Any employer that's using a private exchange on an individual platform and paying for individual policies should talk to counsel, have the facts reviewed.
Okay. For staffing companies, to ensure that customers, worksite employees, are not subject to the $3,000 penalty, must the staffing company charge a fee for each employee who enrolls in staffing company's plan, in addition to a fee across the board for administering the plan, or can the staffing company charge a fee just for the enrollees to prevent the worksite employer from being assessed a $3,000 penalty?
Okay. So in the event, the unlikely event, that the staffing company is not the common law employer, meaning that the employees that the staffing company sends to the client are actually the client's employees under the law, then if the client wants to make an offer of coverage for those employees through the staffing company, then the employer must pay an additional fee to the staffing company for each of its employees who elects coverage through the staffing company's plan. So to answer the question, in that situation, yeah, they would need to pay an additional fee to the staffing company. Whether there's already a fee for ACA compliance built in, that's neither here nor there. If the staffing company is kind of charging an ACA compliance fee and then a fee on top of it for people enrolling in the plan, you might want to take a look at the contract and ask if that's really necessary. In general, most staffing company arrangements are set up where the staffing company is the common law employer. They're the employer of their employees that they send to the client company. And that should sound familiar to most of you out there. I would expect that as a company, you consider the employees you get from the staffing company to be the staffing company employees. If that's the case, then this extra fee is not necessary. It only applies if the client company is the employer and not the staffing company. So, this is a facts and circumstances analysis. We have been helping employers through these issues for several months now. We're happy to engage directly if you'd like us to take a look at any amendment that your staffing company has sent to you, implying that you need to start paying, hundreds of dollars more a month for employees who join the plan. I think it's worth having us take a look at the facts in those situations, because it may not be absolutely required.
All right. Can employers with unionized employees use the Transition Relief Code 2E for line 16 of 1094C?
I don't actually have those committed to memory yet. So, that's something we would need to take up offline. I don't know the indicator codes yet off the top of my head.
All right. Is the pay-or-play penalty applicable for employers with less than 50 full-time employees?
No. The only way that it can touch an employer with less than 50 full-time employees, including full-time equivalents, is if that employer is part of a larger tax-controlled group. Then all employees are aggregated to see if you're over the 50 threshold. There's a single employer, no parent company or subs, and your partners don't own any other businesses. If you have less than 50 employees, then you're generally not going to be subject to pay or play.
All right, and just to follow up from that last one, I'm not sure if it helps, but it says 2E equals multi-employer relief. I did not think that it could apply.
Yeah, that would be one. Send that to the member who invited you today. They'll post it on the portal. We can look it up, and we'll get you an answer.
All right. And it looks like that's the final question. Somebody asked about receiving a copy of the presentation. We will be posting it to the Client Resource Center later on today, so you should find it there as well as the recording. And it looks like to be the final question. So yeah, thank you very much, Stacy, for presenting the material today, and thank you everyone for joining us. We will be posting our compliance webinar for January very shortly, so keep an eye out on the Client Resource Center for that, as well as any of our future webinars. We hope to see you on next year in 2015. Have a great day and a great rest of the year.
Take care, guys. Happy New Year, everyone. Happy holidays.